Hi, my name is AMIRAH binti Muhammad JALALUDDIN and my number matrix is H21A1998.
My name is NORFARZANA SYAZWANA binti ROSDI and my matrix number is H21A2325.
My name is IZZATI SYAZWANA binti AZMAN and my matric number is H21A2435.
My name is Nurul Fatihah binti Abdullah Sani. My matric number H21A2569.
And I will present about the law governing company law in Malaysia. So there are 3 law governing company law in Malaysia. Firstly is statutes. The Company Acts of 777. Secondly is judicial precedent or common law. There are fundamental principles of company law that are based on judicial precedent and applicable in Malaysia. For example, Solomon versus Solomon and Co., which establish the principles of separate legal entity or personality. Lastly is common law, equity and acts of England. Section 3 and 5 of the Civil Law Act 1956, the law of England is applicable in Malaysia. For example, Rilonai Brothers and Co. The decision show that the Malaysian court does refer to English Company Act 1948 to fill the gaps in the local statute.
Next, I will explain about definition of a company. A company is a legal entity that is formed by individuals or a group of individuals, known as shareholders or members, with the purpose of engaging in business activities. It is an organization that operates in the commercial sector and can be involved in various industries, such as manufacturing, service, finance, technology, or retail. Companies are separate legal entities distinct from their owners, which means that they have their own rights, liabilities, and obligations. This legal separation offers limited liabilities protection to the owners, shielding their personal assets from the debts and liabilities of the company. This concept is often referred to as the corporate veil. The formation of company involves a process of registration and compliance with the law and regulation of the jurisdiction where it is established. Company can be formed as different types of entities such as corporations, limited liability companies, LLC, partnership, or sole proprietorship, depending on the legal framework of the country. The key features of a company include legal personality, limited liability, shareholders, management, transferability of shares, perpetual existence, and the last one is regulatory compliance. Overall, a company is a legally recognized entity that enables individuals to come together, pool resources, and conduct business activity with limited liability protection. Its formation and operation are governed by the laws and regulation of the jurisdiction in which it operates.
Now I will continue this presentation with brief a little bit about application for incorporation. Application for incorporation. Firstly, we shall apply for incorporation to register. Second, shall not be formed of any unlawful. Third, shall be a corporation by its name and registration number as it appears in the main record. Fourth, notice of registration as a conclusive proof. 5. It has a legal personality. 6. Endure until it gets removed from the register. And lastly, shall be capable of carrying out all that is assigned to a body corporate.
Today, I will present about a type of company. There are 4 types of company. First, based on liability of member. Second, based on public status. Next is based on relationship with other companies. And lastly, based on place of incorporation. First is a basis of liability of member. There are 2 types based on the liability of member, which are limited company and unlimited company. First, limited by share is a type of company. Where the shareholder liability is limited to the amount they have invest in the business. In a limited stock company, the ownership of the business is divided into equal parts called share. Shareholder who invest a company by share and become co-owner of the business. Next, the amount of the investment of the number of shares purchased by shareholder determined by share of ownership in the company. In a company limited by share, the capital of the company is divided into share to and the shareholders are only responsible for paying for the share they own. Lastly, if the company incurs any debit or loss that interests its asset, shareholder are protected and the personal asset cannot be seized to substitute the company debits. Next slide is limited by guarantee. A company limited by guarantee is defined under Section 10 of the limited company as a one whose member liability is restricted to the amount they have promised to contribute if liquidation or cost. Next, in Section 1922B and 43520, which state that the company has no share capital and members are not obligated to contribute to it. Next, in such a company, the guarantor have to pay for the debit incurred by the company beyond its asset, but only up to the limit of their guarantee. Next is the novelty that the guarantor personal asset cannot be contributed to fully the debit beyond the guaranteeing sum. And the contrary, there are personal granting remain on fact. And lastly, such a liability extends to members who leave the company but join within the 1 year before it closes. Lastly, unlimited company as described in the Section 10 is a business that operates of the foundation of the having no fund improves of the liability of its members. Next, in the event of finding out, this member can be held entirely accountable for the company debit if its assets are infringed. According to Section 11, this variety of company must be classified as either private or public. Next is Section 12, that is the company lack of a share capital and this seldom employed as a trading enterprise. Lastly, it has been used the multi fund wherever corporation maintain assets as an investment among the shareholders.
Type of company based on public status. Public companies are those that offer their shares to the general public and are listed on a stock exchange. They raise capital by selling shares to individual and institutional investors through an initial public offering (IPO). Public companies have a large number of shareholders and are subject to strict regulation and reporting requirements. Some key characteristics of public companies include shareholders, publicly traded shares, regulatory compliance, and public scrutiny. Private companies, as the name suggests, are not publicly traded on a stock exchange. The ownership of a private company is type held by a limited number of individuals, families, or closely knit groups. Private companies can raise capital through private investment or loans. Some key characteristics of private companies include limited number of shareholders, restricted share transferability, limited regulatory requirement, more control and privacy. It's important to note that the distinction between public and private companies can vary across just jurisdiction, as different countries may have specific legal definition and requirement for each type.
Next, I will present about the types of company based on your relationship with other companies, which is holding and subsidiaries. Holding company. A holding company in Malaysia is established for controlling and managing another company's investment policies and assets. In Malaysia, a holding company is a particular kind of business that neither performs any services nor produces any product on its own. Instead, these businesses generate revenue by managing the investments and assets of other companies. Section 4CA. A corporation that is a subsidiary of another corporation and that another corporation is the holding company. Next is subsidiary company. A subsidiary is a different legal entity than the parent business. As a result, the subsidiary is responsible for all of its liabilities. Both foreign and local businesses who want to grow their operations in Malaysia should consider establishing a subsidiary. The company name need not be the same as that of the overseas parent firm, and it is permitted to carry out all business operations. That's all from me. Thank you.
Based on place of incorporation, it has divided by two categories, which is local company and foreign company. Local company. A local company is established in the region in which it conducts business. It complies with regional rules and regulations and complying its own legal standing. Ownership is typically limited to local or citizen, and registration with the local government is required. In simpler terms, a local company is a company that is established in Malaysia and follow the rules and regulations outlined in the Companies Act or any previous laws related to company incorporation. This means that the company has gone through the necessary legal process and is recognized as a legally formed entity under Malaysian law. Foreign company. A foreign company's incorporation takes place in a country other than where its main business is located with branches or subsidiaries in various nations while abiding by local legislation. Foreign shareholder may own a portion of the company and receive reward. Double taxation agreements may be relevant. In simpler terms, if a company from another country wants to operate in Malaysia, it needs to go through the registration process to become an officially recognized foreign company in Malaysia. This ensures that the company complies with the laws and regulations of the country while conducting its business activities. That's all from our group. Thank you for your cooperation and attention.